My name is Sarah Key, and I'm the conference editor at BJESL and a co-organizer for today's conference. We're excited to present today's panel, AI-generated content, protecting the rights of creators in a new era of automation. Our goal is to explore how AI is reshaping creative industries and the legal frameworks that protect the rights of artists, companies, and audiences. From copyright to publicity right to ethical use, we'll dig into both the opportunities and the risks surrounding generative AI. I am thrilled to be joined by our three amazing panelists, Ms. Frances Waldmann, Mr. David Singer, and Ms. Bridget Amoako. Now I hand it over to my co-organizer, Ryan Kim, and he'll start us off with some opening questions for all three panelists.
Hi, everyone. My name is Ryan, and thank you for being here today. So we've prepared a bunch of questions about this panel's topic just to facilitate a discussion among the group. So anyone can jump in at any time to answer. If we could begin, if you please introduce yourselves and the types of work you do.
Sure. Happy to start. Hi, everyone. It's great to be here. I'm Frances Waldmann. I'm a partner in Gibson Dunn's LA office, and I practice in our AI and privacy practice groups. Virtually all of my work revolves around AI and other emerging technologies, counseling on product issues, as well as regulatory compliance issues and litigation.
Hi, I'm Bridget Amoako. I'm an associate in Gibson Dunn's San Francisco office. I work primarily in the AI, IP, and antitrust practice groups. And in that, I do a lot of product counseling on AI issues and regulatory compliance as well.
And I'm David Singer. I'm a partner at Jenner & Block here in Century City, California. I'm also the co-chair of our content, media, and entertainment practice. And like my friends and colleagues here, a lot of my practice is devoted to artificial intelligence, generative AI in particular. And our group historically has represented a lot of the stakeholders in this space, like the studios and record labels, newspapers, book publishers, and tech companies. So it's an exciting time to be in this line of work, but nice to be here with everyone.
Great, thank you all. Just to jump right in, what are the most pressing legal questions that you're seeing as AI generated content becomes more integrated into everything we do, entertainment and media?
I mean, I'm happy to jump in and hear from others. I think, at least from my vantage point, I'd say at least two of the most pressing issues. I mean, one is copyright, and I'm sure we'll talk about that a lot today. And in particular, sort of what the boundaries are with respect to training a lot of these generative AI large language models, and then the outputs that they generate. So, everyone's got their eye on the copyright issues. And I think that, and there's also copyright issues in terms of authorship, which I think we're going to touch on today as well. And I think the other thing that people are pretty anxious about, which touches on these subjects, is name, image, and likeness. Everything from deep fakes to just all-out fakes. There's just a lot of anxiety around not just celebrities or ordinary people, but politicians and others who are worried about the incredible capability of AI to create video of people that looks real but is not. And I think that's got everybody on edge. And I ironically think the only way we're going to be able to police and solve for that problem is probably with more AI. But Bridget and Frances, you want to jump in?
Yes, I agree with David. I think the biggest issues that we're seeing are generally related to copyright. And so those are emerging as questions of what do we do at the early stages of AI system development? Do developers have an understanding of the training data that they're using and any of the IP rights associated with that training data? And then what responsibilities, if any, do those developers have to check and understand the related rights issues there. And then from that, are deployers held to the same standards as developers with respect to that training data? So those are a lot of questions that are emerging. And then on the output side, are those AI outputs copyrightable, as David alluded to? And if they are copyrightable, who holds that copyright? Is it the developer? Is it the deployer? Whether that be a business that's using an AI tool or an individual end user. So, and then stemming off of that is always the fair use questions related to the copyright issues. So those are the things that we're seeing as well.
Yeah, I mean, I agree with all that. Obviously, a couple of things to add. I think we're also seeing developments and discussions around the question of when we can protect AI-generated content in particular. So, separate and apart from the question of, who has certain rights in the context of the life cycle of an AI system, is this prior question of, is it protectable in the first place if it's generated by an AI system? We're seeing that those questions play out across jurisdictions, both in copyright and patent law, and seeing some interesting initial, the preliminary conclusions drawn there about the extent to which that content needs to be human generated in order to be protected. And then the other key issue that I would sort of flag here at the high level is increasingly around content moderation, which is slightly separate issue in relation to the general conception of content and what AI generated content is. It can be sort of data as we perceive it, images, videos, etc., text, but also to the extent that it is content hosted on certain platforms. Are there developer platform responsibilities to moderate that content? And we've seen quite a bit of ebb and flow, I think, around those sorts of questions, especially in the new administration. And this is an issue I think we're going to be grappling with a lot over the next couple of years, particularly as it intersects with some of the increasing requirements to be transparent about what kind of content moderation is being used. If we conceive of content moderation as being the way that we police these systems and introduce guardrails into what they are and are not doing or permitted to be doing. And so, yeah, I think that's another one that we'll come back to, I'm sure.
Are there any recent cases that have shaped your thinking here?
I mean, in terms of the ownership issue, the federal appeals court in DC and the Thaler, I think it's Thaler Perlmutter case, is essentially upheld the lower court, and really the Copyright Office is finding that copyright authorship is human and needs to be human, and that I think did not surprise lawyers who practice in copyright. It was a welcome decision for purposes of clarity. I think that what's going to be more interesting is sort of the piece that the court left open, which is whether humans who use AI as a tool to create an expressive work can still claim authorship over their own sort of creative expression. And I think it's pretty clear from the court's ruling that that's not off the table. There, you can imagine a lot of works, including many that have already been created and made a lot of money and are well known, that have used AI technology in some respect. So imagine it's the difference between asking an AI system or service to make me a movie about a guy and a girl who meet at Disneyland and get married, and then the AI sort of generates this expressive work. That is not going to be copyrightable. But if you are an animator or an animation house and you are creating this kind of expressive story and you're using AI to sort of do the trees in the forest so that every leaf blows the way the wind is blowing, that is still going to be a protectable work, and it won't be considered unprotectable because the humans have used AI as a tool. And I'm sure there'll be all kinds. I mean, we're seeing really interesting and cool developments where people are leveraging AI to make movies. And I think that we're going to see a lot more cases, edge cases, where it's less clear whether the AI is the one coming up with the creative output or whether the human is just using the AI as a tool to get their expressive ideas onto film.
And I think something to add here in terms of maybe where things are headed and some of the challenges that really haven't emerged yet or are perhaps nascent and that we'll likely see in the courts at some point. I think at the technological level, what we're seeing is that for content creation, increasingly those interfaces, those systems are multi-layered and multimodal. And so as opposed to potentially having a creator use it to make a video and then use another tool to layer audio onto it, et cetera, we're seeing those systems be improved, not just at the training stage, but at the system level. And so increasingly those tools can do all of those things. Before, we're not talking about sort of agentic AI and all those kind of frontiers you see, but even just at the system level, they are multi-layered, multi-capable. And to the extent creators are using those systems, those questions of both ownership and I think in particular human contribution become even more difficult to pass because you're not just looking at working on an individual piece of whatever the generation is, but it becomes more of an overall process. So to the extent that we keep moving towards these multi-capable systems, that is also going to be increasingly something we need to grapple with.
Yes, that sort of leads into our next question, which is about current IP laws and whether you think they're sufficient to address issues of authorship and ownership when speaking about AI-generated works.
One of you want to jump in? I'm happy to take it. Go ahead.
Sure. I mean, I think I can sort of start off with maybe a very, very high level point that we've seen from some of the agencies who've been grappling with these questions for a while. We've already mentioned the Copyright Office and Patent Office and the gist of a lot of the guidance that has been coming out of those agencies, and I think is sort of generally seen as being within the realm of reasonable, is that we have laws that can be used to provide protection for creators. It's a question of how we pass their application to these systems, which are not only novel in terms of the application of traditional IP laws, but also constantly changing. And so as soon as the guidance is released, there's some new facet that needs to be explored and considered. And building frameworks around that is really challenging, obviously. But for the most part, we have not seen those agencies propose new laws more generally. That is to say, particularly from the inventorship question and sort of across the board. We are, of course, seeing, and I'm sure others can jump in on that as well, we are, of course, seeing some new laws emerging, particularly in the digital rights realm. So that, I think there is a sense that when it comes to the concept of voice replication or generally sort of the replicating what would be previously human outputs, voice, etc., that those may not necessarily be captured by existing frameworks. And so in some cases, we're seeing new laws pop around those.
Yeah, I mean, I agree. I mean, look, as far as copyright goes, I'm in the camp that believes that the Copyright Act is a really well-written statute. It was written with the future in mind. It is technology agnostic by its own terms. And I think that the Copyright Act and the case law that, on fair use is pretty good. If you litigate under other federal statutes, like the Sherman Act and if you do antitrust law, I mean, there's that's kind of like a 3-sentence statute that causes 100 years of grief. But the Copyright Act is good, and the case law is I think totally equipped to handle this, unless we start seeing courts just going off the rails or kind of misconstruing Supreme Court precedent. I think that we're in good hands with the Copyright Act, and I agree with Francis that I think what we'll start seeing is more states taking up right of publicity legislation the way California did a long time ago, because the common law is probably not equipped to deal with the kind of name, image, likeness, IP type issues that are coming upon us. California is well situated. Other states have, right of publicity statutes, but I see that area requiring some more potential legislation in other states in particular.
Yeah, I agree with both David and Francis on that. And I just to echo the state movement on that, I think we're seeing attempts to expand those rights of publicity to address the AI issues in states like Illinois and Tennessee, and then also as David mentioned in California, particularly following some pressure from SAG-AFTRA to adopt additional protections on that. So we'll definitely see that moving forward.
Yeah, I think one of the interesting things with like the deep fakes, I mean, you've got these like California's right of publicity statute. It doesn't just prevent you from using someone's name, image, and likeness. It prevents you from using that to like advertise or promote a product or a service, which is an important sort of catch. Now, if you're selling a movie that has, an AI version of Tom Cruise, you can't do that because you're using Tom Cruise's name, image, and likeness, in a manner, that is trying to sell that product. But it gets trickier when you sort of have just social media discourse that uses the name and image and likeness of celebrities or politicians when, if you're showing, a deep fake of Barack Obama and you're using it to try to sell BMWs, right? That is going to violate the statute. But if you're just posting deep fakes of a former president saying things that the former president didn't say, you get into a whole world that is really much murkier. It calls into questions of, free speech or parody or potentially defamation. But it's not quite a right of publicity violation because you're not really selling anything. So I think that, just to double click on Bridget's point, I mean, that is going to be, and as a social media kind of, I don't know if I would call myself a consumer compared to my kids, but I'm at least, an observer. I think that's going to be, that's definitely uncharted waters. And I'm sort of waiting to see how courts address that.
Yeah, I think we've conceived as that almost as the Elvis impersonator question, right? Like where is the line at which we have sort of deemed this, deemed the content to be used in a way that we think should be restricted in some way, and because that is to some degree reliant on societal views and pressures, and especially around social media. I think that is I agree. It's completely uncharted waters, and it's also just very interesting because it is so heavily skewed by the perspectives of those using the tools. And those perspectives aren't always shared as between users and lawmakers, I think, at this point in time. And so there's friction there that I think is going to create some interesting issues of policy as well as enforcement level.
And it gets complicated because there's a lot of important First Amendment and free speech issues, right? It's like one thing to, let's say you're making like a Mission Impossible movie, and not to pick on Tom Cruise, it's just an example, but let's say Tom Cruise is unavailable or unaffordable, and then you create a digital replica of Tom Cruise to be the actor to play a role in a movie. I mean, that I think by all accounts is not going to fly. But that's different than if you were doing a documentary about celebrities in Hollywood or Scientology or whatever it may be, and you want to, in your documentary, show real people, whether it's a former president or a celebrity, and you want to tell a documentary story. We all know it's okay to use really, really good hair and makeup. Sometimes, like, the technology for hair and makeup is extraordinary, and you can actually look exactly like a historical figure or a celebrity, and that's okay. But if you do it digitally, that might trip the wire on a statute, you know, and some statutory language that is being considered now. And so, you know, the question is, if you're allowed to do a documentary or a story, a historically accurate story about, you know, someone famous, if you're allowed to use the greatest technology in the world for hair and makeup to make them look exactly like, you know, let's say Barack Obama, but you can't have that done digitally, that sort of raises some questions and interesting ethical debates. I mean, I'm curious if, you know, Francis or Bridget are aware of any sort of, you know, of the potential legislation that really comes down to that question. I mean, I'm very curious about the makeup versus digital question.
I don't know that I have. I mean, I think what those questions really force us to do is to identify what it is about AI and our ability to replicate technically someone's likeness and voice, et cetera. What is it about that is different from, say, the makeup scenario? Not just in how we view it, but, you know, what actually are the implications? And I think, you know, one major implication that's come up, particularly in the context of union negotiations, is the ability to essentially infinitely replicate once you have replicated once, right? So if you created Tom Cruise once for the documentary or for the movie, you know, you most likely have the ability to do so in other contexts. You may not be able to do so legally, but you technically have the ability to do so because, you know, assuming that you have control of the tool that is generating the replica, you know, the way that the generative systems work is generally you will have the ability to generate other versions of it. Right? So it's not necessarily a sort of one-shot output.
Right.
In the same way as the hair and makeup may be, you know, you want to do it again, you have to do more hair and makeup. That ability to replicate and scale, you know, is really at the heart of a lot of the concerns around AI, not just in content creation, but I think here it's really a core issue. It's sort of the kind of slippery slope argument that, you know, if you just think of it as this one use, it might be slightly harder to justify the restriction, but if you think of the consequences of doing so more generally and giving folks access to the ability to do that, you know, ad infinitum, that you have much more serious concerns.
And I guess there's also like a, you know, a consumer perception component. If you go see a movie that, you know, stars a certain actor and you know that they're the actor playing Tom Cruise, no matter how good the makeup is, right? You know that it's, you know, some actor playing Tom Cruise. So there's sort of this suspension of disbelief. But if you go see a movie where it's an actual digital replica and there's no actor playing that role, you know, there's a bit more of or a lot more of the ability to mislead audiences. So.
Yeah, I think about that a lot in the context of growing up in Germany, where a lot of movies are dubbed. And so I, you know, you grew up listening to Tom Cruise sound very different than you all. And and the reality is, you know, watching that, you know it's not Tom Cruise, right? It's somebody else's voice. But you know, what a lot of the tools can do now, are capable of doing now, is creating Tom Cruise speaking German, you know, in a way that you wouldn't necessarily know, or be able to tell the difference if Tom Cruise were able to speak, you know, accent free. Who knows? You wouldn't necessarily be able to tell the difference. And that, as you say, David, that perception issue is now skewed.
Yeah, there's some really cool stuff I've read about that actually, where they use AI to not like to you know, make the voice sound like the actor's voice when they're dubbing, but to also make the lips move, you know, in sync with the words coming out of their mouths. I mean, it's pretty awesome, the dubbing technology, but that's a whole other panel.
Yeah, we could keep going.
On this subject, what kind of transparency do you think should be required from the developers of these models?
Well, I think it just just to start us off, might be worth thinking and sort of thinking about and parsing, you know, what do we think of as transparency in the context of AI systems? So what does that mean? What kind of transparency do we want? Do we need? And why? And so, a lot of the concerns around the opaqueness of systems are around the ability to know whether those outputs and that content is AI generated in the first place. That's essentially what we were just talking about, the voices. So, you might call that, a potentially watermarking or providing a disclaimer that, something is AI generated, or you're speaking with an AI bot or something of that nature. So just the sort of the knowledge that you are interacting with or seeing or hearing AI generated content. Another aspect that's come up in terms of some bills that have been proposed and policy discussions have been around provenance. So not just the ability to know whether it is AI, but who developed it. Who is the developer? Where did it come from? Potentially, how was it developed? A good example of that is what the EU AI Act is trying to do around general purpose AI systems, where there are going to be requirements to provide certain information on the extent to which data used to train those models is subject to existing copyrights. That's an example of not just, is this AI, but the idea that users, consumers, society, other stakeholders should have information about how those systems were developed for various reasons, including the rights question. So those are sort of a few, there are more, but those are a few of the different sort of aspects to transparency, not getting into the kind of data protection side here, which obviously raises other questions around notice that needs to be given when certain data is collected. But just from a broader perspective, there are just a number of different issues that in this transparency bucket. And so because they are all slightly different and interact in different ways, I think that it's a challenging question to think about, what do those systems need to tell us? What do we need to know about those systems? What do developers need to tell us about those systems? So, I think the starting point there really needs to be, what is the system actually doing? What is it capable of doing? I think one thing that's really important to do in this space is to focus on the use case and the impact of the use case, and not get necessarily caught up in the question of what is the model capable of doing? What is the system capable of doing? That's a separate question that also may deserve, some regulation. But from a content perspective, that sort of system level analysis, I think is important. I'll pause there and let others weigh in because I could go on.
Yeah, look, I do think you can't lump together all AI, right? AI and machine learning has been around for a long, long time. And I think everybody is rooting for AI in some sense. We want to cure cancer. We want to create efficiencies. There's lots of great use cases for AI. I think when you get into the realm of generative AI, these AI models that are, on one end of the spectrum, it's just, chatbots that are able to speak a language because they were able to train on everything on the internet, and then they can, speak. But then you've got, these generative AI models that are generating images or video or music. And, that can be very troubling for copyright owners. So in terms of transparency, yeah, copyright owners want to know if their works were copied, as part of this process for these services, which are, ultimately competing with these copyright owners. And so there's going to be there are strong calls for, transparency about training sets. And, in some instances, we're learning that some AI is training on not just kind of the open internet, but on, pirate databases, stuff on the dark web, collections of, movies and books that were copied, unlawfully and that are out there. And do we really want to encourage, exploitation of these sort of, pirated databases? That's troubling for a lot of copyright owners. And then you've also got, training models that are training by going behind paywalls in some instances, for like a lot of, the newspapers are up in arms right now, that, there's AI models and services that are, going behind paywalls, vacuuming up all of the news content, changing the words around and spitting it out as something new. And that's, troubling. But I think Francis is right. We have to be careful to not try to, make broad pronouncements about what all, AI systems should or shouldn't do, because there's great variety in AI and the types of systems out there. But and in some cases, it may be technologically infeasible to have a record of every single thing that you've trained on, and it might slow down technology in ways that we don't want. I mean, one thing I'll say though, and I think there's a misperception out there that, whether that a lot of sort of the creative community, I'll call it, like content owners, that somehow they're anti-AI or anti-tech. I mean, nothing could be further from the truth. I mean, frankly, today, a lot of tech companies are also movie studios, right? So a lot has changed in the past 10 years, but what I hear from sort of the creative community is that there's a lot of excitement over AI. There's filmmakers who can't wait to use it, who are using it. There's, studios, record producers who have been using it for a long time. So there's a wide range of views on AI, and I don't think it's fair to say that you're in one camp or the other. But I do think that depending on the use case, there are going to be greater and lesser needs for transparency.
I think just maybe worth adding there as well, in terms of the trajectory of transparency, not just how we, how some of the laws and some of the sort of emerging regulations are thinking about it, but just how the technology is moving and how the developers of a lot of the cutting edge models are moving. We're going to see a lot of open models, a lot. That's not going to be a trend that's going anywhere. If anything, if you think about it from an adoption point of view, it's likely going to be the case that most models used over the next few years will be open models, where there is this inbuilt degree of transparency, at least to some degree, because by their nature, open models will provide downstream developers or users of those models with information about what their capabilities are and what their limitations are, how they were developed, to varying degrees, of course, and you can argue about what open is and isn't. But the general point here, I think, is that it's not just a question of a template for providing people with a certain amount of information. It may also be that the adoption of AI and the way it's adopted, I think, shapes the way we think about transparency and what is most important in terms of managing those risks that we've talked about.
I totally agree with that, and just to take it one step further, and I think just to sum up what Francis is saying is that a lot of the generative AI models that we're seeing are starting to become more homogenous in terms of their training sets, and there's only so much digital stuff that we've already recorded that's out there and available, whether you agree or disagree with it being copied. They're sort of the playing field is getting leveled, and where the differentiators are going to be is on sort of truly proprietary data that is more protected and going to be available to distinguish different AI systems. Like Grok has access to X, to Twitter, and that makes it really unique in that it has access to everybody's tweets ever tweeted, or that Google may have access to YouTube, or that someone may do a deal with a newspaper or some other content owner, or maybe it's Westlaw. You're going to have kind of this level playing field, and then specialized kind of AI agents or models that have access to a rich set of data, whether it's medical or creative or scientific or financial, that allows that sort of customization and fine-tuning of a particular AI model. And that, I think, 10 years from now, we'll know what different AI models have trained on and fine-tuned on that makes them unique for their case.
Yeah, sort of touched on it a little bit already, but how are you seeing creators adapt to AI's growing role in the creative process?
Well, I can start us off with a couple of points. I think one that we've talked about already is obviously there have been efforts to band together and develop strategies around, especially in the entertainment industry, around union negotiations, and that has led to certain agreements being put in place that are protective with respect to ownership rights and use of, for example, replicas. We've seen that energy translate into some emerging legislation as well, particularly in California. We've seen new bills pop up. In terms of adaptation, I mean, we've obviously seen sort of in the adversarial sense, we've seen the litigation that David's already alluded to around a lot of these ownership issues across different industries, by authors, studios, music owners, etc. But I think the other aspect of this that we've, I think, touched on but haven't sort of dug into yet is the increasing shift to thinking about data and rights in the context of licensing and procurement and agreements terms that essentially govern the extent to which developers and users of AI systems can use creative content and creators' content. And so we're already seeing this, and David mentioned some of the licensing agreements in the context of building systems that are specialized in certain areas like news or the like. But I think more generally that creators are positioned and are positioning to essentially leverage and monetize their content in a way that relies on those licensing terms. We're seeing that across the board. We're seeing efforts even to aggregate some of those rights and sort of build organizations and agencies that will monetize creator content for model training. So we're seeing sort of innovative efforts there. And I think that, that is also going to continue to grow, sort of the knowledge that a lot of the content is valuable because high quality content is valuable. It is more valuable than an enormous amount of low quality content. In other words, the web for the most part, particularly when you're trying to build a system that is very good at doing one thing as opposed to quite good at doing many things. So I think that, there's almost a little bit of a shift there in that creators are realizing the value of their new content and sort of using licensing agreements to monetize it.
Yeah, I mean, I'm curious what Francis and Bridget think about this, but this is less legal and more human, but as a consumer of all this content that I spend my days kind of litigating and counseling about, I always think, about whether an AI generated song or movie or book can really win over the hearts and minds of an audience, right? If I hear, I mean, not to date myself, but if I hear a Bruce Springsteen or Elton John song that I kind of grew up with, the lyrics really matter to me. Because you connect with the experience of, a young Bruce Springsteen or, the scene with Lady Gaga and Bradley Cooper in A Star Is Born, and you feel the emotion. And that's what makes kind of songs and movies resonate with humans, in my opinion. And so I'm so curious, when we get to the point where, there's sort of the first hit song on Billboard that was purely AI generated. Again, I'm not rooting for this. I'm on Team Human, just for the record, and for my clients who are watching. However, I am fascinated and curious to know if I could really ever fall in love with a song, knowing that it was not created by another person that I can relate to. I mean, what do you guys think about that?
I'm pretty torn on this question because I think instinctively I agree, especially when I think of music. But then I also wonder whether it's a feature of, as you say, what we're used to and what we know. I mean, I look at my kids and they are, they're 5 and 3 and they're obsessed with generating cute animals with ChatGPT and kind of other systems. And to them, I don't know that they're having, a lesser experience just because they are not real and they don't exist. And likewise, I think across sort of movies in particular, maybe not so much in music, and maybe that's the key there, but certainly when we think of music and TV, so much of it is synthetic at this point in terms of how it was developed in the first place, from a live action perspective. So I think this might be one of those areas where, we do see change depending on what people kind of perceive as being normal and the norm. But I wonder if music will be the one to stand out there. I'm not sure. I think maybe the reality of hearing something as opposed to seeing it is still a different experience for people.
I think there's also an element of, as we were talking about the different ways that AI is used, is like the different tools that are used. So you might have AI that's generating the song lyrics, but you're still getting a human performer that's doing the performance on stage. And there's still that ability to, I think why influencers are so big is like people connect with the person and then they consume their content because of that. So if a person is able to leverage AI to create a song, but then perform it and have that human interaction, maybe there's a way for those two things to interplay while still giving like the old schoolers among us, because I'm with you, David. I'm like, I need to know what Elton John was feeling to understand some of that. And I think that there's still a possible path for both of those things to coexist, maybe.
We're coming up with ideas for like your whole conference next year.
What role should platforms like YouTube, Instagram, Spotify play in moderating content that was made by AI?
Well, if we're talking about a true like full disclosure, I'm also a longtime believer in Section 230 of the Communications Decency Act. So if we're talking about truly third-party generated content that's being shared on a neutral platform, like, non-infringing third-party content, then I think that these platforms, as defined by Section 230, should have great liberty on how to moderate and express their own speech in curation and moderation. And I firmly believe that these platforms need to have the freedom and not be subject to, litigation based on everything that a third party says or does on their platform, because all you need to do is spend one day as a litigator in America, and that those platforms would not exist in the blink of an eye. So I do think that the convergence of, sort of true platforms and the amount of AI generated content that we're going to see on those platforms is going to blossom and grow. I think that there is still, look, for a platform to succeed and to not turn people off, and that moderation is going to become more and more important. And I think that consumers are going to want to know more and more what is real and what is not. And I think that's going to be, over the next few years, a big differentiator for a lot of platforms that host AI generated content. And a lot, they're already focused heavily on this, but like deepfake technology, detection technology, and AI disclaimer technology, right? I mean, you basically are going to have the bots versus the bots, right? You're going to have a lot of third parties creating AI generated content, putting it up on these platforms, and setting aside the copyright infringement issues. Let's say that gets guardrailed and filtered out, which I expect it will be. Now we're just talking about, what is or is not AI generated. And I think we're probably going to start seeing a lot more labeling, layering, disclaimers about what the platform in its moderation capacity has deemed to be real or fake. And I think we're going to start seeing a lot of that.
Yeah, I mean, I completely agree. And I think the same applies to some degree to moderation around content safety and topic safety, in addition to sort of questions of accuracy and whether something is AI generated in the first place. I mean, some of the efforts of this this administration are somewhat focused on, you know, the substance of the content and the extent to which that's moderated. And I think it's interesting and instructive actually to think about and sort of step back and think about what do we mean by moderation in this context, because sometimes I think our minds jump to straight to the interface in the same way as, say, you know, how are they editing the newsletter or the paper in terms of sort of determining what is on the front page and what is kind of getting priority. But when we're talking about these systems, that moderation can happen, you know, across the life cycle, and it can have very different impacts on the content. You know, it can happen, as you say, David, at the in a filtration stage where, you know, we're telling the system not to output certain content that, you know, is likely to be subject to copyright and may infringe on other rights. But maybe we want the entire system to stay away from a certain type of content. And so there are sort of lots of different ways to pass this issue of moderation. And I think that leads us to another content-related issue when it comes to platforms and moderation, which is the extent to which there is divergence across not just jurisdictions, but also sensitivities, but I think importantly jurisdictions for us lawyers, in terms of what is deemed harmful in particular and objectionable, and what should not be output by these systems and may actually be illegal in the context of those systems in certain jurisdictions. So then we're thinking less about, you know, how do we want this system to work, how to avoid exposure for certain copyrights, sort of the sort of ethical, responsible approaches and sort of mitigating that legal risk, but also, you know, how do we ensure that the system isn't producing content that is harmful or illegal. And you see CSAM is a good example of that. How do you secure for that? How do you ensure that the systems aren't outputting that kind of content where there is consensus generally around the fact that it shouldn't be generated by these systems, but there's not that much consensus around exactly what the system shouldn't be outputting. And a good example of that in the context of CSAM is, you know, is text. CSAM, you know, not in the US, but it is in other jurisdictions. So that is also creating kind of a patchwork of risk and requirements and ethical considerations around moderation. It makes it sort of very challenging to conceive of it as one issue with one solution.
I just have one last question here to sort of wrap up our discussion. If you could each answer, that'd be great. Just personally, what trends or developments in AI are you going to keep an eye on this year, each of you?
I mean, other than the obvious kind of boring answer, which is all the copyright stuff that I'm watching with, you know, bated breath every day. So, you know, as a lawyer, that, you know, that's just what I've got my eye on, and that's kind of critical to me to see how that all shapes out. I do think that I think a lot of people are waiting to see. I don't think we've yet seen sort of the true. We've seen a lot of stuff with AI, like deep fakes, that's scary. As copyright owners, we see a lot of some of this like generative AI stuff that's seems like it's gone too far and it's violating owners' rights, and that's troubling. But these are really just kind of the tips of the AI, you know, iceberg, or I don't even mean to be derogatory. They're really just the beginning of a new future. And I think what we're going to see in the next few years, once we start seeing sort of the impact on science, for example, and discovery, like I've been reading about LLMs that aren't even trained on language. They're trained on, like, you know, the sort of human genome and sequencing of the DNA. I mean, we're going to be able to, like, you know, not me, but other people who are smarter than me are going to be able to use AI and are using AI to come up with vaccines in 1/100th of the time. And I think that once we start seeing, you know, the impact on science and education and health and longevity, I think we're kind of look back on, you know, generative AI and all this fighting over copyright as, you know, this tiny little blip, you know, on the screen of history. And so I'm excited for the big stuff. That's what I'm looking forward to.
Yeah. Oh,
Oh,
go ahead,
sorry.
Bridget.
No. Okay. Yeah, I share David's optimism about some of the things that are a little bit outside of the wheelhouse of what I do day to day, outside of the copyright and the digital replica sense. So science, especially as a closest I got to science was political science major. So again, the smartest people over there doing whatever they do with AI, I'm really interested in how that'll go. I think in terms of what I'm looking for at work, I'm interested in how states and the federal government kind of deal with the preemption issue. I think we're seeing a lot of individual laws and regulations crop up, and seeing how developers and to a lesser extent players maybe are having to consider those things and try to adapt to the shifting framework as lawmakers aren't sure what they're going to do. It's exceedingly difficult for a developer to know how to respond to that. So really interested in which way that will go and which sort of framework will be the one that's adopted. Will it be one that's focused like on high risk scenarios, high risk uses of AI, more targeted sense, or something broader that just targets the any use of AI? And so that I think will shape a lot of where this goes moving forward. So that's what I'll be watching.
Yeah, that's a great point. I think my sort of what I think I'm most focused on as a lawyer in my day to day, I think is trying to identify and waiting for, to some degree, the convergence. I think in terms of where a lot of the laws around content in particular and transparency are headed as between different jurisdictions, and that includes, to Bridget's point, between states, we're seeing at the federal level, what we're seeing internationally, because the reality is that a lot of those stakeholders developing these models, especially the most advanced and frontier models, those issues are for the most part are international. And so, watching as lawmakers and stakeholders are grappling with some of the issues across transparency and how to think about, conceptualize transparency in the context of providing information on how a system has been developed, et cetera, without sort of completely undermining the development process and halting innovation completely. Seeing that convergence across, for example, laws in California and laws in the EU is really fascinating, and we'll see where that lands. It's going to impact, I think, the development of enterprise systems and systems that we as individuals can use in a much bigger way, I think, than people are necessarily thinking about, because it determines what the interface looks like ultimately and what developers are or are not able to do in terms of developing their systems. And I think more broadly, similar to David's point, just watching the trajectory of the development of a lot of these models. For a while we were focused on scale, and the models were getting bigger and bigger with more and more compute, and a lot of the kind of regulatory thinking in terms of what lawmakers were doing was really focused on that and sort of thinking about that scalability question. But really, that's not necessarily the direction we're headed in. We're not just thinking more about use cases and focused training and optimization and developing systems that are really good at one thing, but also just the systems are increasingly developed in a different way, are infinitely more capable than they were a few months ago. So if that trajectory continues, then to be honest, we might be thinking about completely different concerns a year from now.
I mean, totally. I mean, I know we're at time, but like, you don't need to be a rocket scientist. All you need to do is have access to YouTube to know that the humanoid robots are coming. The AI is getting smaller and smaller. The AI is going to be inside those robots. And so if you're like in law school now and you're thinking about the future and where lawsuits are going to go and liability and all those issues, I suggest like watching more James Cameron movies than reading case law, because I think science fiction is a better guide right now than than some of the legal texts we have. But yeah, a lot of interesting things coming.
Thank you to you three for a great discussion. I'm going to just send it back to Sarah to close out our panel.
Well, thank you so much for the great insights in AI and media. And I'm sitting in the dark, but I'm learning a lot. So to close our panel, a lot of the people that are watching are inspiring attorneys who wish to get into entertainment and AI law like myself. So we appreciate just a very quick words of advice for all of us that are watching. Just one sentence.
I was very recently in your shoes, so I can start. I think for me, it's being open to not necessarily knowing the answers to the things you're asking questions about and just really digging in. So I did not have a tech background, and I was willing and able to ask those questions and try to get enmeshed in things that I didn't fully understand and still am learning every day. And so it's really just being comfortable being uncomfortable and continuing to learn in an area that's constantly shifting.
And I would add to that, which is a great point that I completely agree with. I would add to that, don't underestimate and undervalue what you can bring to the table as a law student, as a junior lawyer who has been, enmeshed in this environment, learning about technology, learning about Gen AI as something that is somewhat normal. These are things that even those of us who haven't been practicing for that long learned while we were already experienced practicing lawyers. And this is a field where you need to think about it not just as a lawyer, but as to the extent you can, an engineer. You really do need to think about sort of how the technology works, as well as the kind of policy issues around it. And that is something that you are going to be much more familiar with than most practicing lawyers are. And so don't underestimate the extent to which that familiarity and that kind of comfort level with the technology puts you in a great position.
Yeah, it's funny. The three of us are circling around the same point to finish off on, which is, you're in great law schools, you're going to learn the law, but you need to get your hands dirty, use the products, right? Like if you're in law school now, you should be using ChatGPT, Grok, Perplexity, Gemini, just get your hands on all of these products, use them, interact with them, and kind of experience it. And that's the only way you're going to be able to marry sort of all the law and theory that you're learning and apply it in the real world. So instead of reading about all these products in the newspapers, my advice is to use them, get out there, experience what they can do. And like Francis and Bridget were saying, you're just going to get smarter if you do that. So that's my advice.
Well, thank you so much. It was such a pleasure learning from all three of you. And I hope you have a great rest of your day. Thank you so much.
Thank you. Thanks for
Thanks so
having
much.
us.
Yeah.